Namaste and welcome to our 97th episode of AAA weekly webinar series. As probably there is some difficulty in the link today, and as this subject that is very, very important, I think there are a lot of people, they are not able to join. So we have four very, very important topics today. One is the detailed analysis of Greater Noida Industrial Development Authority versus Prabhjit Singh Soni judgment of Honorable Supreme Court, which was given by the Supreme Court on 12th February 2024, and today is 17th. Within 5 days, this judgment has become very, very important for most of the real estate cases. Secondly, the liquidation process regulations were amended by IBBI on 12th of February, and the corporate insolvency resolution process regulations were also amended by the IBBI on 15th of February. 2 circulars were also released. So therefore, we in fact we have prepared all this for our audience. And however, the most important is to start with the regulations, and then we will go to the judgment of this Greater Noida Authority. See, when we come to the regulations, so the first focus of IBBI is regarding the compromise or arrangement. This is provided in Regulation 2B of the Liquidation Process Regulations. Now, the intent of IBBI is that there should not be hurdles in the liquidation process because of the option available under Section 230 of the Companies Act. So the present regulation says that this process of compromise or arrangement proposal should be finished within 90 days from the date of order of the liquidation. And also, like any person who is not eligible under Section 29A cannot submit even cannot submit a proposal under Section 230. Now, there was also a proviso earlier which was introduced on 16th of September 2022, that was that where the recommendation to explore. See, in fact, this power was given to Committee of Creditors under Regulation 39 capital B and capital A of CIRP regulations. So in that regulation, this power was given to the Committee of Creditors that in case they feel appropriate, then they will also pass a resolution that the proposal under Section 230 may be considered, and that particular resolution will be filed by the RP in the application for liquidating the company. So this was the regulation which was added on 16th of September 22. Now, in this amendment, the intent is that it should not be an open process. Now, it is very clearly said that the proviso actually is changed. Now, it says that the liquidator shall file the proposal for compromise or arrangement only in cases where such recommendation has been made by the committee under Regulation 39BA of CIRP regulation. And also, the liquidator shall not file such proposal after the expiry of 30 days from the liquidation commencement date. So earlier in Regulation 39BA of CIRP regulations, it was actually very, very clear that in case the Committee of Creditors decide that the liquidator may explore and examine the possibilities of any compromise arrangement under Section 230, then in that case, the time between filing of the liquidation application and the order of the order for liquidating the company, that time should be used for exploring such possibilities. So now it is said that assuming that the committee first of all approved a resolution that the liquidator will examine the possibilities, and even our committee shall examine the possibilities to explore the explore like kind of possibilities of compromise or arrangement under Section 230 of the Companies Act. So that is first the committee will decide, and then the committee will also work on finding the possibilities during that period between filing of the application and the order of the liquidation. And once such possibilities are seen, then the liquidator will make an application within 1 month of the liquidation commencement date. Therefore, in most of the cases, first of all, this resolution under Regulation 39BA would not have been passed. Number two, the applications by the liquidator have not been made under Section 230. Therefore, now in some of the cases, we have seen that even after 2 years of the commencement of liquidation, the liquidators are filing applications for compromise or arrangement under Section 230 of the Companies Act. So that is what the intent is. Intent is that if it has to be explored, it will be explored within 1 month. So this is the amendment which the proposal exploring the possibilities under Section 230 is a kind of a sunset clause. We would not see many proposals for compromise or arrangement under Section 230 of the Companies Act. Now, the next amendment is in Regulation 14, which is regarding the early dissolution. The regulation says that after filing the preliminary report, where the realizable properties of the corporate debtor are insufficient to cover the cost of the liquidation and the affairs of the corporate debtor do not require any further investigation, then he may apply to the adjudicating authority for early dissolution of the company even immediately after the filing of the preliminary report. Now, the amendment is that before filing this early dissolution, the liquidator will consult consultation committee, and if it advises for early dissolution, then he may apply along with a detailed report incorporating the views of the consultation committee. So the early dissolution, it is not depending upon the liquidator only. It needs the consultation of the stakeholders consultation committee. 3, it also needs the detailed views of the consultation committee, why they want to liquidate the company, why they want that the affairs of the corporate debtor doesn't require any further investigation. So this is the amendment. So the basic intent is that the early dissolution is also within the powers of stakeholders. Liquidator alone cannot decide. And since in some cases where no claim is received during liquidation process, then the committee of creditors, which was there in the CIRP process, will decide about this. They would decide whether the company has to be liquidated or not. Now, further, there are amendments in Regulation 31A, which is regarding the stakeholders consultation committee. First of all, its constitution, and also the kind of matters on which the stakeholders consultation committee can advise. So there are various matters, but there are various other matters which are now being added to their power. So the liquidator will actually go to stakeholders consultation committee for many more things, and few more things which are added, I can say. One is the review of marketing strategy in case of failure of sale of the corporate debtor as a going concern. So in case the corporate debtor's sale of a going concern fails, then it will be reviewed by the stakeholders whether the further sale of corporate debtor as a going concern has to be tried or not. So that is the one power which has been given to the stakeholders. Otherwise, there are other amendments also which is related to the corporate debtor sale as a going concern. Then is the continuation or institution of any suit or legal proceedings by or against the corporate debtor. That also has to be now approved by the stakeholders. Even continuation or institution of any suit or legal proceedings by or against the corporate debtor. So that also has to be decided by the stakeholders, where the cost-benefit analysis would be done, and then it will be decided whether the litigation has to be pursued or not. Then the other is the extension of payment of balance sale consideration as provided in clause 12 of para 1 of schedule 1. Now, schedule 1 is basically the mode of sales, and in that schedule there is a clause 12 which says that the payment by the bidder, by the highest bidder, will be made within 90 days. Now, the stakeholders has been given the power that the period can be even period can be more than 90 days. So in some cases, the IBBI got the feedback that the amount is very large. It may be difficult for some people to provide the total amount within 90 days. So therefore, the committee, in fact, before even the auction committee, the stakeholders consultation committee will decide before the auction that what would be the total time permitted in the liquidation process beyond 90 days. However, there is no exemption on the interest. The interest will be charged after 30 days for the entire period. Earlier, it was only 2 months. Now it can be 2 months plus any other period, because in case there is an auction of 400 crore, then there may be, the SEC may think that this particular auction needs 6 months or 1 year time for the entire payment. So this is the amendment in the stakeholders consultation committee. Basically, the various issues which are supposed to be consulted to stakeholders consultation committee. So the 3 new issues have been added: marketing strategy in case of failure of sale of corporate data as a going concern, then continuation or institution of any suit or legal proceeding, then extension of payment of balance sale consideration. It can be extended now beyond 90 days. However, interest would be charged. There are further sub-regulations in Regulation 31A, which is a regulation for stakeholders consultation committee, and one sub-regulation 6 is presently talking about the meetings of the consultation committee. And present law is that the liquidator can have the meetings of the consultation committee. First meeting is within 7 days, and then whenever it is required, the meeting can be conducted by the liquidator. Now the law has been changed. First meeting, of course, will be done within 7 days, and in case there is a request from the members, then again 33% of the power holders, they can request. Now there are 2 provisos, in fact, added into this. Like after the first meeting, the subsequent meetings within 30 days of the previous meeting. So there will not be a gap of more than 30 days between 2 meetings. However, there is a power which is given to the stakeholders consultation committee. They can extend the period between these meetings. They can say that yes, it can be 30 days or it can be 90 days or in between 60 days. So it cannot go beyond 90 days in each quarter. In each quarter, 1 meeting is mandatory. In each quarter, 1 meeting is mandatory. In case the consultation committee does not agree, then the meeting will have to take place every month. This is the sub-regulation 6, which has been added. Now, the other regulation, which is 6A, has been added. In case the 6A regulation, which has been inserted in Regulation 31 capital A, it says that in case the liquidator proposes to continue or initiate any legal proceeding, he shall, after presenting the economic rationale for the proposal, seek the advice of the consultation committee. So the economic rationale has to be provided for each litigation, even continuation or institution. Another regulation has been inserted, which is Regulation 6B, and there in each meeting, the liquidator shall present to the consultation committee, number 1, minimum agenda. So this is the minimum agenda that has to be taken up. 1, the actual liquidation cost along with the reasons for exceeding the estimated cost. This is the mandatory agenda. Number 2, the consolidated status of all legal proceedings. Number 3, the progress made in the process. These are the minimum agenda, and this minimum agenda is actually in every meeting it has to be there. Further, the sub-regulation 9, it was in fact amended on 16th of September 2022, and 1 word was added, that was voting. That actually means that the 66% of the representatives of who are voting, out of those who are voting, 66% vote should be in favor of that particular consultation, that particular action. Now it is only a clarification because simple word voting was not very clear. So they have just clarified that the voting shall mean voting cast by the representatives of the consultation committee. So I am giving an example. In case out of the 100% power of the stakeholders consultation committee, in case 80% only vote, in case 80% only vote and 20% do not vote, out of the 80%, we have to see that 66% of 80% vote in favor of the resolution, and the resolution will be considered as passed by not less than 66%. It has been done. It has been done because in the stakeholders consultation committee, the voting power has been given to even the government authorities, even to GST, even to income tax department. Voting power has been given to them as well. So in many cases, we have seen that these departments are not really participating into the liquidation process. So they do not come, or if they do not vote. Even if they come to the meeting, they do not vote. Because see, in some cases, the permission from the sanctioning authority is not given. So therefore, the voting only, in case 80% of the total stakeholders having voting power of 80%, 66% of the 80% would be enough for passing a resolution. Now, as I said that we will come back to sale as a going concern, there are some amendments which are actually now given in the sale of going concern. First of all, Regulation 32 capital A says the sale as a going concern, the liquidator may sell the assets of the corporate debtor under clause E of Regulation 32 exclusively only at the first auction. This was the Regulation 32A, and exclusively only at the first auction. Now, there is an explanation added to this. The explanation is that for the purpose of this regulation, it is hereby clarified that the sale of the corporate debtor under clause E of Regulation 32 cannot be offered as the only option for bidders after the first auction. This is the present regulation. Now the sub-regulation 5 has been added, where the liquidator is of the opinion that it is viable to run the corporate debtor as a going concern. He shall consult the consultation committee, and only on its advice he shall run the affairs of the corporate debtor as a going concern to the extent approved. So, keeping the liquidator as liquidation, keeping the CD as a going concern, that also it requires the approval of the stakeholders. And when we actually will come to the liquidation cost, then the liquidation cost incurred on the operations of the company for keeping the company as a going concern will also have to be approved by the committee stakeholders, and also the whether to keep the company as a going concern, whether some operations are supposed to be run, that also has to be mandated by the stakeholders consultation committee. Now, the Regulation 33 is also amended regarding the mode of sale. Now, mode of sale is it's basically the private treaty. It says that the private treaty can also be done, and the private treaty can be also done in case asset is perishable, in case the asset is likely to deteriorate in value significantly if not sold immediately, or if this asset is sold at a price higher than the reserve price of the failed auction. So this particular clause was something was a hurdle. It was interpreted in the manner that it has to be, if the asset is not perishable, if the value is not likely to be deteriorated, then in all those cases where the auction fails, then only you can go for private treaty. And then adjudicating authorities sanction is required in case it is a related party transaction. Or then now the amendment is that the private sale can only be done after consultation with the stakeholders. SCC will decide whether the private sale has to continue or not. And once the SCC decides, then that condition is removed. That condition that the asset is sold at a price higher than the reserve price of a failed auction, that particular condition is withdrawn. However, the approval from the prior approval of the stakeholders consultation committee is added. So if the stakeholders will decide, then it can actually be sold at any price at a private treaty. Regulation 35 is also amended because the Regulation 35, there is a commonality in the two numbers. One, the Regulation 35 of the CIRP regulation also deals with the valuation, and Regulation 35 of the liquidation process regulations also deals with the valuation. Now, it says that in case the CIRP valuation is not used, then the liquidator is of the opinion that the fresh valuation would be conducted. So that is what is the powers with the liquidator. Now that power also will have to be has to be exercised in consultation with the stakeholders consultation committee, whether a fresh valuation is required in this case or not, or whether we are continuing to use the CIRP valuation. Now, in this case, another regulation, sub-regulation 5 has been added. It is said where the fresh valuation is conducted, the liquidator shall facilitate a meeting wherein the registered valuers shall explain the methodology being adopted to arrive at valuation to the consultation committee before finalization of the valuation report. The further sub-regulation 6 has been added, saying that the liquidator shall share the valuation report with the members of the consultation committee after obtaining an undertaking that they shall maintain the confidentiality of such reports and shall not use these reports to cause an undue gain or undue loss to itself or any other person. Now, in case we will come to the CIRP regulations also, the valuation reports now are supposed to be shared with the committee of creditors. Even the fair value is supposed to be provided in the information memorandum. Of course, the COC can decide not to provide, but the fair value as primary responsibility of the RP is to provide fair value in the information memorandum. Now, the valuation reports also would be shared with the stakeholders, and in the liquidation process also, the valuation report will be shared with the stakeholders after taking an undertaking. Now, even in this process of getting a valuation done, if there is any deviation of 25% in the valuation of an asset class, when we see the deviation of 25%, then it has to be only asset class wise, not overall. Asset class wise, it has to be 25%. Then, in that case, the liquidator shall facilitate a meeting wherein the registered valuer shall explain the reasons for the difference to the consultation committee. So wherever there is a difference between the valuations, then the liquidator will convene a meeting of the valuers and to discuss and understand why there is a difference in the valuation of both the valuers. So they should try to reconcile in case it is possible. So they can also, the reconciliation is also possible. So in case reconciliation is not possible, then only the third valuer would be appointed. However, primarily both the valuers should reconcile, and then if one is wrong, they should accept the error and they should modify their valuation report.
Do we have the requirement of third valuer in liquidation? I think it's always
the third valuer in the liquidation is not a requirement as of now.
There. So therefore, if the difference is too much, then we are only trying to reconcile or understand the differences from the valuers, and that's about it. If the difference is significant, even then the average will continue to be the reserve price, right?
No, I believe then the stakeholders would have the power to appoint another one in case there is a no reconciliation between the two valuers and the difference is huge.
The regulations don't provide for a third valuer in liquidation. CIRP, yes, that should be the case.
CIRP provide, but then there is no provision for third valuation.
But so here the simple average will continue to be the reserve price.
I also feel that when the power has been given to the stakeholders consultation committee in Regulation 35, I think that power where the liquidator after consultation, a fresh valuation is required. So the stakeholders can decide, or they can even adopt the average of the two. This is what is my opinion. If the difference is huge and the stakeholders still can decide for the third one. Otherwise, the average of the two can be adopted.
Yes.
So the last is the Regulation 46, which is regarding the corporate liquidation account. So the corporate liquidation account is being maintained by the IBBI, and wherever there are two kinds of money which is available with the liquidator: one, unclaimed dividend; two, the undistributed proceeds or undistributed or unclaimed proceeds. So it was it was somehow deposited to the corporate liquidation account. Now the difficulty is, what difficulty is faced, that once the money is deposited to IBBI, then probably the liquidator has no power to get it back in case any person comes back to the liquidator. Now that power has been given to the liquidator also. If any person comes back to the liquidator, then there is a process which has been defined that the liquidator will fill Form 1 for the withdrawal, and then that will be distributed after taking the money back from the IBBI. So that's what is the amendment. So I think I'm trying to say that it is the liquidator also, in case the company is not yet dissolved, then the liquidator can also apply for taking it back from the IBBI. That's in brief, that power has been given to the liquidator also. The regulation 46A, which is freshly inserted, is exclusion of certain assets from the liquidation estate. This is very important for real estate cases. Now, it was a kind of undecided matter. It was unresolved matter whether all those units of real estate which has been handed over to the allottees, and in case of liquidation, what will happen. Now it has been clarified by the regulations that the liquidation estate under Section 36 will not include all those units of a real estate project where the possession has been handed over to allottee. Those assets shall not form part of the liquidation estate. So the most important is that all those who have taken the possession from the builder or from the RP, those people are safe, even if a resolution plan is approved or not. Even if the company is liquidated, those allottees are safe. So that is very important, because this was also an argument where the project-wise insolvency was argued, and also a reverse insolvency, because see, most of the real estate builders were saying that we have 1,000 or 2,000 or 10,000 such home buyers or allottees who have taken the possession. So it is very clear that they are not disturbed. They have the possession, so they will not become part of the liquidation estate. Now, in this amendment to Schedule 1, which is the mode of sales, the amendment is that the first, the liquidator shall mention in the option notice what is the total period which is prescribed by the SEC for making payment. Earlier, it used to be only 30 days plus 60 days. Now, the liquidator will mention what is the total period approved by the SEC. Is it 90 days or more? So this is the one amendment. Then the existing mode of sale, existing process of sale was like this: that once the first auction fails, then the liquidator can reduce the price by 25%, and subsequent only 10%. So the first auction on the reserve price based on the valuation. Second auction, the liquidator may reduce by 25%, and subsequent only 10%. Now the amendment is that the first auction is say as per the reserve price. Second auction, it will be reduced by not more than 10%. However, in case the auction fails, then the stakeholders consultation can decide that in one of the auction they can reduce the price by 25%. Only in one auction in the entire process. Now, what happens is originally the first auction was at reserve price, and second can be at 75%. Now the second will be only at 90%. However, at one point of time, the SEC will have the power to reduce by 25% from the last auction process. This is what is the rule. This is what is the amendment made now. See, on another amendment in the mode of sales, the as I said, that the 90 days has been given for making the payment. In this case, in case the payment is not made in 90 days, then the auction will be cancelled. Now it is clarified that it is 90 days or the total period which is sanctioned by SCC. After that, the sale will be cancelled. So this is a consequential amendment. And as far as this private sale is concerned, the private sale shall be confirmed by the confirmed to the buyer only after the consultation committee approves it. So the private sale will have to be approved by the consultation committee. So the most important is there is a schedule which has been inserted. Schedule 2 was already there, but then the schedule 2 has actually been amended. So this is a schedule where the performer has been prescribed for reporting to stakeholders in a stakeholders consultation committee meeting. One that we have seen that the meeting would be every month unless the stakeholders approve a period of the meeting which cannot be like more than 90 days, because see, in one quarter there has to be one meeting. In this format, many important aspects have been added, like the date of meeting, date of last meeting, number of days in the last meeting, agenda of the last meeting, any agenda which was not approved, appointment of professionals, sale, manner of sale, bid qualification, fees of the liquidator, valuation, status of litigation, preliminary report, So all this is supposed to be there in that format. All this is supposed to be there in that format, which is provided in Schedule 2. And that will be the format of the report, which will be attached to every meeting of SCC. Further, the Form H is basically prescribed as a compliance certificate when the liquidator will submit an application for either closure of the liquidation process or for dissolving the company. Why I'm saying closure? Because in some cases the corporate debtor has been sold as a going concern, but the liquidation process has still to be closed. So in that case, also Form H is required, and in those cases where the company has to be dissolved, also Form H is required. So there are a lot of amendments in that, and most importantly, there has been a column added like how much assets have been sold under auction, private sales, assignment, and distribution of unsold, that the total will be seen. And then the Form H will also see the kind of those securities which are not relinquished to, which are not relinquished to the liquidator. That is also a kind of, and also the detail of assignments also is supposed to be provided. So Ankit, we have finished this part. And in case there is any question on this, we can see that. And probably we can see, otherwise like the CIRP regulations, we should quickly do, because it's like the such large amendments, I believe we would not be able to take up within 1 hour the Greater Noida Authority judgment. Although that's a very important judgment.
So we should continue, and I believe there are a few questions, but I think if we take the questions, we will not be able to do justice to the CIRP regulations. So we are in a fix. I think CIRP regulations, talking about them, and that will be more important.
Okay, so we are continuing with the CIRP regulation, which was actually given released by IBBI on 15th of February 2024, and today we are talking on in the morning of 17th. So our team and myself and Ankit, we have prepared the complete analysis of the CIRP regulations given by IBBI on 15th. Now, this is the first amendment that we have seen is Regulation 4, and it is simply saying that in case of a real estate project, the RP will open separate bank account for each real estate project. That RP or IRP will open a separate account. That is only to facilitate project-wise accounting of the real estate cases. Coming to the Regulation 18, which provides for the meetings of the COC. So now the resolution professional shall convene a meeting of the committee before lapse of 30 days from the last meeting. However, this interval of 30 days can be increased by the COC. However, one meeting in 1 quarter, that means 1 calendar quarter, is important and it's must. So one meeting in a month, or the COC has the power to increase the time. Instead of 1 month, it can be 60 days, it can be 75 days, or it can be 1 quarter. So that is the regulation which has been inserted. Regulation 25 again is added regarding the voting by the committee. So now, see, the feedback which has been given to the IBBI is that there is a lot of delay in voting by the members of the committee. Now, the amendment has been made in Regulation 25, which is governing the voting process. Now, it says that the members who did not vote at the meeting on the matters listed for voting by electronic system, they have to vote by electronic system. And of course, the minutes will be circulated within 48 hours of the conclusion of the meeting. And the voting shall be kept open from the circulation of the minutes, for such time as decided by the committee, which shall not be less than 24 hours and shall not exceed 7 days. 1. The meeting time can start only from the time of the circulation of the minutes. Number 2, the
Voting
time.
Voting time.
Sorry?
Voting time.
No, it has to be the voting time. First of all, the voting time has to be calculated from the circulation of the minutes. So the time is like for such time as decided by the committee, which shall not be less than 24 hours and it shall not exceed 7 days. So it should be between 24 hours to 7 days. Now, the maximum time that we can give to the SCOC for voting is 7 days. However, the members, any one member has the power to request for extension. And one extension cannot be more than 24 hours. One extension cannot be more than 24 hours. Further, the RP has been mandated that not to extend the voting window where the matters listed for voting already received the requisite majority. Now, suppose a resolution is already sufficient voting has been done. In some cases, more than 50%. In some cases, more than 66% has already voted. Maybe in negative or maybe in positive. Thereafter, there is no requirement of waiting further. So, therefore, the RP will close the voting and will see that will make a declaration that the resolution is passed or failed. So now this is something which is very important, because in some cases we are extending the voting even up to 1 month, especially in the approval of resolution plans. It is to that extent it has been, but now also that every time a member will ask for extension, RP will extend it for 24 hours. So second time, third time, fourth time. So there is no limitation on this extension. Now the RP can be asked 10 times, RP can be asked 20 times. So I think this is not something which is putting pressure on the stakeholders. Rather, it is increasing the work for them as well as for the RP, that they definitely would wait for their committee to declare whether the resolution plan is approved or not. But this is basically increment is for 24 hours, not more than 24 hours. Actually can be done at one extension. Now, the regulation 31B has been inserted in CIRP regulation, and it actually says that wherever the CD is, see, there is a belief, and there are judicial pronouncements also, that any expenditure or loss incurred for keeping the company as a going concern is not something which needs approval of the committee of creditors. Now it is clarified that the insolvency professional shall place in each meeting of the committee the operational status of the corporate debtor and shall seek its approval for all costs which are part of the insolvency resolution process cost. Now, in case we are keeping the company as a going concern, that means that every month the RP will be required to present a profit and loss account and a receipt and payment account, so that whatever is the loss, whatever is the additional expenditure, that or whatever is the kind of diminution in the value of the current asset, that will be considered as part of the CIRP cost, and that would need the approval of the committee of creditors. So this is very, very important. This amendment actually will increase the workload. This amendment will increase the workload. So therefore, there will be a requirement of appointing an accountant, and there will be a requirement of appointing a person who actually will be preparing every month a kind of operational status. Now, the operational status is not something which is a real English. It is a mathematics that has to be presented before the COC. It has to be told to the COC, this is the amount which actually will become part of the CIRP cost, which may be loss, which may be expenses, and which may be diminishing in the value of the current assets. That also will become, because see, there is a first of all, beginning of the CIRP, there are some assets which are handed over, and then it is continuing in the custody of the CIRP. So any loss, any damage, any expenditure will become part of the CIRP cost, and that would be approved by the Committee of Creditors. Regulation 35 is also a very, very steep change. Regulation 35 deals with the valuation, where the fair valuation and the liquidation value is supposed to be assessed, and it has to be assessed as per the asset class. Now, the amendment that has come, the amendment is that the RP shall facilitate a meeting with wherein the registered valuers shall explain the methodology being adopted to arrive at the valuation to the members of the committee before computation of estimates. And then it is said that now the RP, after the receipt of resolution plans, in accordance with the code and these regulations, the RP shall provide the fair value, the liquidation value, and valuation reports to every member of the committee. First of all, it has to be after the receipt of the resolution plan. What we are supposed to give to the members of the COC? Fair value, liquidation value, and the valuation reports in total to every member of the committee in electronic form, on receiving an undertaking from them that they will keep the confidentiality, they will not use this particular valuation report to their gain or somebody else's loss or somebody else's gain. So this is the amendment, which is a kind of a very big amendment, that the valuation report has to be shared after the resolution plans are approved, but still it is not before that. However, in the information memorandum, the fair value is required to be given. However, the COC has the power whether to restrict or to give. But as far as the RP is concerned, RP has the power to give the fair value in the information memorandum. That means the valuation has to be completed before the information memorandum. So
this meeting, this facilitation meeting or the valuation methodology meeting has to be done now for all the cases where valuation is still pending? And the valuation is,
yes,
the values are already appointed?
The valuation, in fact, that regulation was already there, Ankit. The resolution shall facilitate a meeting. The meeting in case earlier also we are getting a meeting done only to discuss the methodology.
But this regulation was not there. Now the regulation requires it. So yes, we kind of yeah. So where we are appointed as valuers in AAA valuation, we attend those meetings where the COC wants the valuer to come and discuss the valuation report. Rarely have we gone for a methodology to be discussed. But the question is that all the cases where CRP is going on, valuation is still not final. The change in this regulation would require the RP to call for the valuer to come in and explain the methodology, right?
Yes, I believe in case the report has not been finalized in all those cases.
Where in the report cases, it is requirement.
Yes, in those cases where the valuation report has not been finalized.
Right.
So in information memorandum, where the regulation 36 has been amended slightly, and that says that the one is that the RP is supposed to say that we actually now can provide the fair value. The clause KA has been added where the fair value can be given in the information memorandum, provided that the committee may decide not to disclose the fair value if, for the reasons to be recorded in writing, it considers such non-disclosure to be beneficial for the resolution process. So the fair value is also something which is can be given in the information memorandum, other than what the COC decides. Like the COC decides not to give, then the reason has to be recorded. Regulation 36 capital A is regarding invitation of expression of interest, and there is a clarification which is given, and that's only a clarification that the resolution professional, after approval of the committee, may invite a resolution plan for each estate project, each real estate project or group of projects of the corporate debtor. So therefore, the separate invitation for expression of interest can also be released. Form G can also be released for one project or a combination of projects. Now, the regulation 38 is regarding the mandatory contents of the resolution plan. So there are many contents under regulation 38. So there are further regulations which have been, there are further mandatory content which have been added. So what are these mandatory content? These are mandatory contents regarding the requirement of a monitoring committee. See, first of all, the committee may consider the requirement of monitoring committee for the implementation of resolution plan. First of all, it may consider. So there is a possibility that the monitoring committee may not be there. Secondly, where the committee considers that a monitoring committee for the implementation of the resolution plan is required, it may, while approving the resolution plan, decide to constitute the same with the resolution professional or propose any other insolvency professional or any other person as its member. So the committee will propose the members of the monitoring committee. So it is saying, while approving the resolution plan, decide to constitute the same with the resolution professional or propose any other person or any other person as its member. Now, what I'm trying to say, it is not mandatory that the successful resolution applicant also has the power to nominate their person. So far, it was only a tradition. Now, the COC can actually propose a monitoring committee without the SRA, without a representative from the successful resolution applicant. Further, proviso says that provided that where the RP is proposed to be part of the monitoring committee, the monthly fee payable to him shall not exceed the monthly fee received by him during the corporate insolvency resolution process. So it cannot be more than that. So it is something which is now classified that it cannot be more than that. So now number one, that it is possible to constitute a monitoring committee without SRA, only one member of the SRA, and the other members can be from the creditor and the insolvency professional or the RP. Now, this is also very important. Now, regulation 40, this is regarding extension of the CIRP period. Now, in this case, presently it says that the committee may pass a resolution and direct the RP to file an application for extension of CIRP period. The only amendment is a clarificatory amendment that the resolution professional shall continue to discharge his responsibilities under the CIRP till the application of extension is decided by the adjudicating authority. So this is these are the regulations, liquidation regulations and the CIRP regulations. So we actually can see in case there are questions. And one thing is very clear that this Noida authority, Greater Noida Authority judgment, which is impacting the real estate, that we will discuss in the next webinar, because this is 1 hour is something that we have decided. And there are some hand raises, and we can even say that those hand raises actually can be
quickly starting up. So Mrinal Gunjanji is asking that the compromise time of 30 days is mandatory or it is indicative. I think it is mandatory. It can't exceed that 30 days, right?
No, it is first of all regulation 39BA of CIRP regulation. In that regulation, the COC has to decide whether there is anything to explore regarding 230 compromise or arrangement proposals or not. In case the COC decides no, then there is no time available.
Okay.
Then the liquidator will have no power. But in case the COC decides under regulation 39BA, then the RP and the COC will work during that period when the application for liquidating the company is filed, but the order is not yet passed. Okay. And thereafter, immediately on the liquidation order, that 230 proposal under section 230, within 1 month it will be filed to NCLT. That is what is the law. It is mandatory.
So the liquidator cannot go for compromise or arrangement unless it is recommended by the COC, right? That's clear.
That's clear.
Understood. So that was also a question from Mr. Hari Prasad. Then we have a question that the 30 days meeting time, that the meeting has to be done within 30 days or within the quarter. So you have to serve the notice prior so that you can convene or have the meeting before 30 days, right? Unless and until it is adjourned for any reason.
No, I think the meeting, it is the time for the meeting. It is not the time for the notice.
Notice
The
will
notice,
precede. The
notice
notice needs
period.
to be planned so that the 30-day period does not
Yes,
exceed,
yes, yes. So
right? So everyone will have to see when the 30 days are exceeding, and maybe a week before, 5 days, whatever is the
yes,
timeline, they will then serve that notice.
right.
Then we're talking about voting of a home buyer in case of a liquidation. What will happen there? So it will again be through the authorized representative, the way it happens in CIRP, or no?
So they are stakeholders in liquidation, and in case their asset is not part of the liquidation estates, and they may file their claim for the residual services which are left. So they are the stakeholders, and they are the stakeholders. So they also can have the authorized representative, and the voting would be done through authorized representative.
But those home buyers who have received possession are no longer
So
members
that
of the,
asset, that particular asset would not be considered as a liquidation estate. However, the home buyer may have a claim that
which is over and
my
above or some other.
my unit was incomplete, or there are some work which is left in the common areas, and there were some commitments made by the builder to me which has not been complied with. So those kind of claims can still come.
All right. So if SEC decides, this is Rashmi ji asking this. So if SEC decides for private sale at low price, then also then approval is also required from the NCLT for such private sale.
No, the approval from NCLT is required only in three cases. One, in case the private treaty is with a related party to the RP, related party to the corporate debtor, or if the private treaty is only to a professional appointed in the process. Otherwise, in other than these three, there is no requirement of getting approval from the adjudicating authority. Now, the condition, that condition that you cannot do the private treaty uh, at less price than failed opposition. If the failed auction at 40 crore is failed, then you can only do the private treaty at 40 plus something. But now the SEC can decide the private treaty and the price of it. No requirement of NCLT.
So question from Chanchal Dua saying that how will we consider stakeholders who were present in the SEC but who chose to abstain from voting, and will that abstainment be counted as negative votes?
No, it is the voting. The clarification has been given that even if a person has not attended the meeting but voted, or even if the person have attended the meeting and not voted, both are covered.
We are
Yani,
saying that, but we are saying attended the meeting and abstained from voting. He filled in the
yes,
voting sheet. Yeah.
yes. Coming to that, attended the meeting and abstained, not attended the meeting and voted. However, only those people will be considered as voted where the actual voting has been done, maybe yes, no, or even abstained. Voting has been done. That button has been clicked, yes, no, or abstained, because the abstained also will be considered as no then. So
Abstained will be considered
anyone
as
who,
no.
yes, anyone who has not voted is out.
Right. So then we have a question where sometimes valuation is not possible due to non-cooperation by the CD, even IA filed by under 19(2) and all that. What do we do then? I think the valuation has to be closed based on the best information that is available, taking various assumptions. You can't just hold on to the valuation. So there is some information which is available. Maybe financial statements are available, physical assets are available. In case the regulations are very clear now after the previous amendment that the last year's amendment, that in case the list of assets is not provided to the RP is required to prepare the list of assets on his own. So this is how the valuation can happen. For tangible assets, for securities of financial assets, we rely on whatever information is available. So speaking from our experience, we have had no difficulty in closing the valuation for any case whatsoever. But yes, wherever information is not available, the values tend to be towards zero.
Now, I feel that the information memorandum where this fair value can be given by the RP. So information memorandum is something which is a dynamic document. It can be 1 version, 2 version, 3 versions. So the information memorandum can be issued without the valuation even, and later on it can be updated.
Right.
Before the resolution plans are submitted.
Meaning whereby comply with the presentation. So basically, yes. So then next we have Mr. Hari Prasad asking, sir, is it the deviation of 25% of value between the valuation done under CIRP and valuation done in liquidation? However, the reserve price is the value arrived under liquidation. I think the
This is
variation.
right, Ankit. This is absolutely right. When I was saying this, the 25% difference which is there in the regulation, that is in comparison to the valuation obtained during CIRP.
Yeah.
Now the regulations say that in CIRP we obtained a valuation which is 100 crore, and in the liquidation we obtained a valuation which is 70 crore. So there is a difference of more than 25%, and the methodology of how to calculate the difference is also provided in the regulation. In that case, we have to bring all these valuers together to reconcile the valuation. And also,
I think the word is used is not reconciliation. The word used is that the valuers have to come and say why there is a reason, and that needs to be recorded in the minutes. It is not reconciling. So we are not asking the valuers to change their report. We are asking the valuers to come and share why the value is less than 25% or from the CIRP date. The second change that has happened in the liquidation regulations, which is also aligned to this change, is that in case you go for use the CIRP level regulation, CIRP level valuation for reserve price, then in the first instance you can decrease your reserve price by 25%. But in case you use the fresh valuation under liquidation, then the decrease is not beyond 10%.
I don't think this is the one.
This is also coming. This is also part of the changes in liquidation regulations.
The liquidation regulation says that the reserve price has to be fixed in case it is fixed on the CIRP or it is fixed on the valuation obtained during liquidation process. The reserve price has to be fixed on that. First is the reserve price, then is the reduction in the auction and the reserve price in case the first auction fails. Now, if the first auction fails, the price will be reduced by 10%. And during the entire auction processes, one opportunity can be given to the stakeholders to reduce it by 25%. When we were talking about the comparison of 25%, that comparison was between the valuation of CIRP and the valuation of liquidation. That was the comparison between these two valuations.
And I will just bring out that part of what I was saying.
You see, we can get it clarified later, but then we can actually see in case there are questions, because already we have reached 1 hour deadline.
Yeah. I have just found it. I will just quickly share it. So this is the one that I was talking about in this schedule 1. There is a change that in the clause 4 here, that the reserve price shall be the value of the asset arrived at in accordance with regulation 35, and where auction fails, the reserve price shall be further reduced by not more than 10%. Then there's a proviso that in case you're using 35(1), where you're using the valuation from CRP period, then you can decrease it by 25%.
Yes.
So there's a differentiation in the whole process.
So this is a 10% only. This is the okay. So 10% in case the valuation is done in the liquidation process.
25% in case the valuation is from the CRP period.
And also further you can reduce it by once 25% in the entire process.
Yeah, 25 you can use only once, so 10 is what then goes on for the remaining process.
Okay, but
so
then okay.
So then other questions. Is there any timeline for engaging the valuers? 7 days is the prescribed timeline, but in case the SEC says that okay, whenever SEC permits that okay, the valuation should be done again, then of course you can appoint the valuers at that point in time. That's always possible, right?
But then there is a timeline which is required.
Timeline which is required to be adhered. A lot of other questions, but I think we are short of time, so maybe we'll have to cut it short and take these questions offline.
Yeah, I think we will also conduct the next webinar on this, the Greater Noida judgment on real estate, along with the changes in the real estate, in the liquidation, so that we actually can give the perspective what is going to happen in the real estate cases now.
Right.
That we will discuss in the next webinar coming Saturday at 11. Thank you very much. Thanks a lot.
Thank you.
Thank you.